Welcome to Bill the Lender podcast, devoted to educating you on a variety of financial subjects with an emphasis on real estate and real estate finance. Please click the button to subscribe to my channel so you don't miss an episode. Then like and share your favorite episodes. Hello, everybody, and welcome to today's episode of Bill the Lender podcast. I'm Bill the Lender, your host, and today I have a unique guest, Ted Finn. Ted has been actively participating in law in Longmont and throughout northern Colorado since 2003. His law practice historically involved the defense of large and small employers regarding all types of labor and commercial liability cases and issues. Now, Ted's practice is currently grounded in family and divorce law and personal injury prosecution. Ted understands these cases are some of the most important and difficult that he can handle. His experience in the intricacies of litigation is matched by his understanding of the unavoidable emotional component of these cases. Ted's goal is to ensure his clients have a clear understanding of the law, their options, and the likely results of the decisions they make. He personally handles all aspects of litigation, including initial investigation, evaluation, motions, discovery, mediation, and trial. A lifetime Longmont resident, Ted is actively involved with numerous civic organizations and is dedicated to preserving the atmosphere of community he enjoyed while being raised in Colorado. Ted, welcome to the show.
Thanks, Bill. It's good to be here.
Yeah, man. Super excited to have you because, family law is one of those things that is a pretty big determiner of somebody's personal assets and wealth.
It is.
And we have a lot of our listeners that are budding investors or they're first-time home buyers, and they're looking to get their first home maybe before they get married. And so bringing you on the show and talking about how you as a financial service provider deal with real estate and dividing up assets in the case of a dissolution, I think is a pretty big topic.
It is. There's a lot to go into that and a lot to unpack. But I think one of the things that I talk to my clients about in particular is that there's not an aspect that a dissolution of marriage won't touch on. It touches on your ability as a breadwinner, your identity as a spouse, a lot of times as a parent. And so there's not an aspect of your life that won't be impacted in some fashion. And so when you talk about how do we protect your ability to provide for yourself and your family moving forward, there's a lot of things that go into that. One of the things that is a misconception, I think, in Colorado in particular, is that Colorado is not what you would think of as a 50-50 division state. A lot of places will essentially come in and cleaver the marital estate in half, saying it's 50-50 this way or that. And that's not what Colorado does. Colorado is what's called an equitable division state. And so that means ultimately if you end up in court, the court's going to divide your marital estate however the court thinks is fair. And so you use that backdrop to say, okay, well, then if we know that going in, then how do we make it so that we have a fair allocation that protects that kind of hierarchy of things that are important? And so if one person or the other wants to stay in the house, or if it was property that was brought into the marriage, if it was separate property that came by gift or inheritance, then we have to be thoughtful and mindful as we go through all of this and saying, okay, how do we title things on the front end? If you're talking about pre-dissolution planning or even pre-marriage planning, you talk about, do we keep separate assets separate? Is the application of a prenuptial agreement something that we should be discussing? And is it something that can be done? In Colorado, it can, but it requires some forethought. One of the things they talk about in Colorado is that if you're doing it on the eve of marriage, it's likely not going to be enforceable. You have to have a complete financial disclosure. You have to have the ability of both sides to have the seeking independent counsel. And doing a lot of those things takes time and forethought that can't be done on the fly. And so you have to do these things ahead of time, and you have to do them mindful about, even if a prenup is in place, is it going to be enforced fully? If it's not, how can you protect yourself from the gaps? And then there's also the availability to do a post-nup agreement, which is called a marital agreement in Colorado, that once you're married, you can order your assets and make sure that things are clearly demarcated for how we're going to dissolve our marriage, but also how we're going to dissolve our joint property. And it's a lot of things that go with that I think most people don't think through, because you're in love and you want to get married, and you don't ever anticipate that it's going to go poorly. But unfortunately, doing what I do, you can see it does go poorly, and we just need to be thoughtful as we go through it.
Well, let's face it. I mean, you're entering into a relationship. It's a significant relationship. Nothing says I've got doubts like having a prenuptial conversation.
It's a hard conversation to have, but there are ways to do it, Bill. I mean, that's one of the things I talk about with my people, is to say it's not an indictment of your relationship. It's not anything to say I don't love you, or that I'm not committed long-term to this relationship. It's just simply a way to order and be methodical about, this is what we have, this is what we're going to do. The material aspects of it aside, it's simply just a way to kind of eliminate confusion, eliminate uncertainty. And we all know uncertainty breeds hard feelings and doubt, and those things can lead to additional issues going forward. And if you're providing certainty, you're ahead of the game.
Well, I like that. So let's break this open a little bit, because, you just brought up some really, really good points on a prenuptial agreement that I didn't even really know, that it needs to be done ahead of time. You can't do it on the eve of a marriage. Both folks have to have access to separate counsel. And if you have all of those in place, even then it still may not be honored. So are there productive ways for you to reasonably go into relationships? Let's say if you are an established investor who already has a property prior to the marriage, and then is going to plan on, in this case, let's just say, acquiring property with the partner that is now marital assets. How does the court see the difference between the two?
Right.
And which instrument could you talked about a post-marital or a marital agreement. Could you delineate that and have it feel fair?
Right. So one of the main things that people have to focus on when you're dealing with propertied individuals versus non-propertied individuals, if you have property in a divorce, the court's going to divide what's called the marital estate. And the marital estate is anything that came to the marriage that didn't come by gift or inheritance. And so if you have that kind of overall definition of what we're going to be dividing in a dissolution, then we plan on the front end before you're married to do a premarital agreement, which people think of as a prenuptial agreement. And in a premarital agreement, what you're going to be talking about is, okay, if we have separate property that the propertied spouse had prior to marriage, what you're going to want to do is you need to maintain the separate nature of that property. And so there's a presumption in Colorado that if you were to put both parties on title, that you've essentially made it marital property at that point. And so what you want to do is you want to have good values at the date you're married, and you want to have good equity statements, right? So we got to have debt and value. So we're knowing, what the actual amount is, because that's another piece that's going to affect the validity of the prenup is you have to make a full and complete financial disclosure. You have to put all your cards on the table, and you have to say, this is everything I've got, and this is what I'm considering separate, and this is the value of it at our date of marriage. And so now I've been able to carve off, okay, that's separate property. The issue in Colorado is marital property, if not properly accounted for in a prenuptial agreement, will include the increase in value in separate property. So say I own a house and I have, $500,000 in equity on the date we get married. That is separate property, whether there's a prenup or not, assuming I keep it separate, assuming I don't commingle it, assuming I don't make a gift to the marriage. But at the date of dissolution, now that property is worth $1 million. I have $1 million in equity. That $500,000 increase is potentially marital property. So even though we could carve off the 500 on the front, then you're potentially dividing the other 500 on the back. And so a prenup can address that to say, okay, we're going to order our property so that any separate property, including any gains on separate property, remains separate property. And you can do that as long as there's the full and fair disclosure, there's independent counsel, it's not done on the eve of marriage, there's independent time to consider. The one thing that you can't do that courts are very clear about, especially in Colorado, is when they're interpreting a prenuptial agreement, you talk about a maintenance allocation, right? Which is what people consider alimony, right? And so you talk about spousal support. A court always has the ability to determine spousal support, even under a prenup, as to whether it's unconscionable or not. And so there'll be factors in there where you could say, how long have you been married? What's the standard of living? There's a whole list of things in the statute that need to be considered. So when I say you can, even if you do everything right, there's still nothing, there's some things that you can't account for under the prenup. That's one of them, is the court will have to determine that at the time of enforcement. And so if you've been married for 20 years with a prenup and the other spouse has not been earning outside of the house, that would be something that would need to be looked at. And so what you'd want to do with some careful planning is then build in a provision about, okay, if we're married for this long, then it's this much. And really, it's trying to be fair. If you're, courts in general has been my experience over the last almost 20 years, courts are going to look for people that are trying to get one over on somebody else. And they're probably not going to let that happen. And if you're going into it to be fair, to be reasonable, and to do it based on the contribution of the parties, the economic status of each of them when we get done, it's probably going to be a much more favorable outcome than if you go in and you try to put them through the ringer and you try to say, if you leave me, you're never getting a dime, and you do all these things. You just have to understand you can do that. There's probably attorneys that will do it for you, but the chances of success are not great.
Well, let's talk a little bit about that, because I feel like, you're in the throes of divorce now. It's a hugely emotional issue. You're either very, I don't know how many times you probably would give me the stats on your clients and how many people come through where it's amicable versus it's contentious and there's a lot of emotion wrapped up in this. I know I have been divorced 7 years and we're still going through mediation, right? So I feel like more often than not, it's probably fairly contentious. Is that true?
It can be. And a lot of that depends on who's involved, right? It depends on the attorneys that are involved. And one of the things that I try to do in my practice a lot is talk about expectations, right? And one of the first things I say to people when I have a phone conversation with them is, if you're calling me to grind them up and spit them out, that's not me. My job's to get you divorced. And if you want to stay and fight about the spoons, you can do that for free. You don't have to pay me a bunch of money to do that. So what you have to do is say, okay, we're going to understand expectations. And the only way you can do that is to have clear financial numbers. We have to know what's out there, what it's worth, is it separate property? And then once we have all of those factors put together, then we can have a guided conversation about, this is what's a reasonable outcome. And there's a range of outcome between there. But the way people or my clients are able to insulate themselves from that kind of animosity and that kind of emotion that's tied into it is we stay methodical. We come up with what we think a reasoned approach is. And if the other party wants to have a reasonable conversation, then we do and we get it done. But if they don't, if they go and hire a chest beating attorney, if they're, so upset that they want to put the other spouse through the ringer, then we just simply say, let's go talk to the judge. And then I will explain to the judge what I think our reasonable outcome should be based on the facts and the law. And you're able then to kind of insulate yourself. You have a reasonable expectation. You have an understanding of what the law will and will not allow. And if everybody wants to get on the reasonable train, there's plenty of room. And if not, then I'll run my reasonable train right to the judge and we'll do it the other way. But you have to have the ability to insulate your clients from the emotion because, like I said, the very first thing when we started, it touches on everything. And it is very difficult not to be emotional about it.
Well, yeah. And a lot of times, like you have already mentioned, there's often spouses or somebody that either may go back to the workforce or is looking for maintenance or a quality of life after divorce. And so, how does that play into some of these different outcomes in those? Let's take those two specific situations. Sure. You've got somebody who has been out of the workforce for the past 10 years. Maybe he or she, because it's either one these days, have had a budding career and then decided to change that to because they had kids and they wanted to give those kids that homeschooling, quality of life, good education, whatever the reasons are. In that situation, how does that impact that outcome and the reasonable outcome?
Right. There's a lot of factors that go into that. And that's when I talk about having a global picture, that's one of the things that's most important, because I think where people get in trouble when, especially before I see them, is they have informal conversations with the other spouse. And it's like, okay, this is what we're going to do with the house. We're going to divide it 50-50, or we're going to let mom stay there because, that's where the kids feel most comfortable. And again, an admirable goal and one that we would like to see if we could make it happen. But it doesn't account for everything else that you have to deal with. At the end of the day, when you're dividing assets and debts, you don't want to be partners on the Visa bill. You want to be able to say, okay, one person's going to take the Visa bill, but then they would take a concurrent amount of assets to account for that debt. And so the idea would be then, how do we make those positions work one way or the other? And that includes maintenance. And we have to understand, when we're talking about maintenance especially, is understanding what everybody's priority is. Some people, they would think, okay, I need 2 or 3 years to go repolish my degree and then go get back into the workforce. And so it may be that we're willing to pay a higher amount for a shorter duration to get them through that transition period and then give them a runway on the way out. It may be that you have people that are on the cusp of retirement and they're 5 or 6 years away from being able to draw Social Security. And so what you'd want to do then is pay them a shorter, or, a smaller amount for a longer duration. It may be that we have to take some of the assets, when you're talking about liquid assets, if we sold the house, if we have cash on hand, that, okay, we're going to take some years off of that maintenance provision because we're going to give more cash from the asset distribution. You have to think about retirement accounts are not liquid, right? And so that's not a dollar for dollar exchange, because if you draw your retirement account, you're going to have to pull probably a 10% penalty and probably a 22% income tax payment on it. So you're really talking about 66 cents on the dollar. So if I shorting the maintenance amount and then I increase the asset distribution, how far do I have to increase it? And so when we talk about maintenance in particular, it's important to have a global view of everything that's out there. And then specifically, when we talk about if the non-earning spouse is going to try to stay in the house because of the kids, how is she going to refinance the house? Because, Bill, you know this better than anybody. Bank doesn't care what you guys agreed to in the divorce. Bank's got earner on the mortgage, and they're going to, if not getting paid, they're going to come knock it. And it impacts your ability to go get a second house or to go get additional financing if you're already on the hook for the first house. And so then,
so let's talk about that too, because I feel like, as a financial service provider, you guys, regardless of market conditions, and we are in a crazy one right now with 7%, over 7% interest rates. Life circumstances, slight divorce will force your hand regardless of where rates are.
That's right.
And you have to pay the spouse out, try and keep the house, and provide that stability for the family, which is a significant concern for all parties involved.
Right.
And the court wants to oversee that. So how are you working with mortgage professionals to make sure that things go as planned?
It's important to have, especially as you're starting a divorce, that you have good people that can rely on good experts, because I'm not an expert in lending. I don't give opinions about things that are banking regulations and things like that. And so you got to have a team of professionals that we can go to, especially like appraisers. If I need an appraisal, I need values, I need the number to come in at this amount. But when you're talking about lending in particular, one of the things that I've seen come up recently, especially, is if that non-earning spouse is going to be receiving spousal maintenance, or what people think of as alimony, how long does that have to be paid for before it will be considered sufficient for a lender to provide good funding? If they have assets that are producing income, what does that look like? A lot of people have rental houses these days, right? And so if I have an asset producing income, maybe we want to shift some rentals over, so then you can able to show consistency in income, which I know is going to be important when you're talking to lenders. And so it's important that whoever you're dealing with, the divorce attorney wise, lenders wise, that they understand that it's a symbiotic relationship. You have to work together. So attorneys can promise you that they're going to do this or do that, or I'm going to get you to keep the house. But at the end of the day, rubber's got to meet the road, and there's only so much money to go around. And we have to be able to then take that limited pot, present it to the bank and say, this is what we've got to work with. And then that's someone like you that's going to put that creative lending hat on and say, these are the holes we can chase down and see what we need to do. It's important to have a team.
Yeah, absolutely. And I think that there's a proactive piece to that before you're ever even getting to the outcome. You know, the alimony or maintenance question is they have to receive it for 6 months. So often, you know, we're saying, okay, so if you're going to negotiate a settlement date, it needs to be after, you know, it could be in the 5th month.
Right.
So that the 6th month alimony payment's going to come in on time. And as soon as that date hits, maybe it's between the 1st and the 5th, we can still close by the 10th, right, or whatever that looks like, so that they have the 6 months and we can document that in the bank. But if you're not getting those folks in the conversation early and you're trying to bring a successful settlement to the judge, you know, underwriting guidelines can change at the drop of a hat, particularly in a market like this where things are falling apart.
Right.
The wheels are coming off the bus.
Right.
And a monetary policies changing depends on, you know, how well the individual mortgage companies that you may be reaching out to are funded or capitalized or what have you.
Right.
And things can happen. So it's always definitely good to consult somebody up front.
Right. Because a lot of the backstop of that is if you can't get it refinanced, then what do we have? Right? Because then do we have to trigger a sale provision? Then we have to get into the details of who's going to choose the listing agent, how are we going to choose the sales price. I mean, it's just a lot of things that go into it that I think a lot of people could be well informed about, but if you're not sure, you need to talk to somebody that knows. You need to find somebody that you trust that knows what they're doing.
Absolutely. Well, this has been a really great conversation. Ted, if my listeners have more questions or they want to, you know, tickle your ear with their individual situations and ask some advice, what's the best way for folks to reach you?
It's always a call. I've got a great staff. Robin, my paralegal, is the best I've come across in 20 years. And so usually they call out and set an appointment with Robin, and she'll get it in there. The number is 303-776-5380. We're happy to help in any way we can.
Well, cool. Well, this has been another episode of Bill the Lender podcast, where we talk about all things financial service related and how it impacts your real estate and real estate finance. Until next time, I'm Bill the Lender, and we'll talk to you again very soon. Take care. Thanks for listening to Bill the Lender podcast. Please reach out to me with any questions at 303-877-6323.